Business Studies 2.2 Forms of Business Organization. Subscribe. Lotus Education Institute. Complete Coaching and Career Counseling.
Company organization. A company is that form of business organization which is willingly established by some persons for earning profit under the Companies Act. Many persons jointly invest capital in a company and, therefore, it is also called joint stock company. Its capital is divided into transferable shares, which means that its shares can be generally bought and sold. Liability of its member is limited. The business of a company is stable and its business is run through a common seal. Till now in India the incorporation of companies is done under the Indian Companies Act 1956. But now Companies Act 2013 has came into existence. Joint stock company. A joint stock company is the largest form of business organization. It is an association of persons formed for carrying out business activities and has a legal status independent of its members. Companies are compulsorily to be registered under the Indian Companies Act 2013. Definition: Company. Section 2(20) of the Companies Act 2013. Companies means a company incorporated under this Act or under any previous company law. Features of companies. 1. Incorporated association. 2. Separate legal entity. 3. Artificial legal person. 4. Formation. 5. Perpetual succession. 6. Control. 7. Liability. 8. Common seal. 9. Risk-bearing. 10. Transferability of shares. Merits of company organization. 1. Limited liability. 2. Transfer of interest. 3. Perpetual existence. 4. Scope for expansion. 5. Professional management. Limitations of company organization. 1. Complexity in formation. 2. Lack of secrecy. 3. Impersonal work environment. 4. Numerous regulations. 5. Delay in decision making. 6. Oligarchic management. 7. Conflict in interest. Types of companies. Small company. Small company means a company other than a public company. 1. Paid-up share capital of which does not exceed 50 lakh rupees or such higher amount as may be prescribed, which shall not be more than 5 crore rupees, or 2. Turnover of which as per its last statement of profit and loss does not exceed 2 crore rupees or such higher amount as may be prescribed, which shall not be more than 20 crore rupees. Dormant company. The Indian Companies Act 2013 states that a Company Act 2013 states that a company can be classified as dormant when it is formed and registered under this Act for a future project or to hold an asset or intellectual property and has no significant accounting transaction. Such a company or an inactive one may apply to the Registrar of Companies, ROC, in such manner as may be prescribed for obtaining the status of a dormant company. Company limited by guarantee. It means a company having the liability if its members limited by the memorandum to such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. Company limited by shares. It means a company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. One-person company OPC. Definition: one-person company refers to a company which has only one person as a member. Causes of the formation of OPC. 1. Making the unorganized sector as organized. 2. Stopping the formation of private company by wrong means. Features of OPC. The main features of one-person company. 1. Only one person is required. 2. Status equal to a private company. 3. Appointment of a nominee. 4. Joint holder. 5. Limited liability. 6. Special words with the name OPC. 7. Number of directors. 8. Meeting of directors. 9. Annual General Meeting AGM. 10. Perpetual succession. 11. Separate legal entity. Formation of OPC. The main stages in the formation of OPC are the following. 1. Giving separate name. 2. Appointment of a nominee. 3. Bearing OPC with the name. 4. Depositing documents. 5. Certificate of incorporation. Advantages of OPC. 1. Limited liability. 2. Good alternative of sole proprietorship business. 3. Sole shareholder. 4. Sole director. 5. More logical. Entry in an organized sector. Limitations of OPC. 1. More formalities. 2. Shortage of resources. 3. Unbalanced decisions. Types of companies. I. Private company. According to Section 268 of the Companies Act, 2013. A private company means a company which by its articles of association 1. Restricts the right of members to transfer shares. 2. Restricts the number of its members between 2 to 200. The following are not counted among the members. A. Who are present employees and also the members of the company, and B. Those people who were previously the employees of the company as well as its members but now are no longer its employees but continue to be its members. 3. Puts a ban on inviting the public to subscribe to its shares and debentures. 4. Puts a ban on inviting the public to subscribe to its public deposits. Five. Must have a minimum paid-up shares capital of 1 lakh rupee. This amount of capital is subject to change from time to time. It has to add the word PVT Limited after the name. 2. Public company. According to Section 271 of the Companies Act, 2013. Public company means a company which is not private. A public company is one which 1. Has no restriction on the transfer of its shares. 2. Has no maximum limit on the number of its members. 3. Has no restriction on inviting the public to subscribe to its shares and debentures. 4. Has no restriction on inviting the public to subscribe to its public deposits. 5. Has a minimum paid-up share capital of 5 lakh rupees. This amount of capital is subject to change from time to time. For the establishment of a public company, there should be a minimum number of 7 members. It has to add the word Ltd Limited after the name. Formation of a company, various stages. Formation of a company means bringing a company into existence and starting its business. If involves completion of a lot of legal formalities and procedures. As a company is a legal entity, certain legal procedure for its formation is to be followed. The steps involved in the formation of a company are: Steps of formation of company. 1. Promotion stage. 2. Incorporation or registration stage. 3. Capital subscription or commencement of business stage. One. Promotion. Promotion means conceiving a business opportunity and taking an initiative to form a company. A company, being an artificial person, requires somebody who conceives a business idea, decides to form a company, takes decisions about its size, type and structure, takes preliminary steps for its formation and assumes associated risks. Those responsible for taking such decisions are called promoters. Promotion. It involves conceiving a business opportunity and taking an initiative to form a company so that practical shape can be given to exploiting the available business opportunity. Any person. A group of persons. A company. Promoter. A promoter is said to be the one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. Apart from conceiving a business opportunity, the promoters bring together the men, material, machinery, management abilities, financial resources and set the organization going. Legal position of promoters. Promoters are neither the agents nor the trustee of the company. Promoters enjoy a fiduciary position with the company, which they must not misuse. Promoters are legally entitled to claim expenses incurred in the promotion of the company. The company may choose to reimburse them for the pre-incorporation expense. The company may remunerate them for their efforts. The company may allot them securities. Steps in promotion functions of a promoter include: 1. Identification of business idea opportunity. 2. Feasibility studies. 3. Name approval. 4. Fixing up signatories to the Memorandum of Association, MOM. 5. Appointment of professionals. 6. Preparation of necessary documents. 1. Identification of business opportunities. The first and foremost activities of a promoter is to identify the business opportunities. The opportunities may be in respect of producing a new product service, making some product available through a different channel, or any other opportunity having an investment. 2. Feasibility studies. The promoters undertake detailed feasibility studies to investigate all aspects of the business they intend to start, depending upon the nature of the projects. A. Technical feasibility. B. Financial feasibility. C. Economic feasibility. 3. Name approval. Having decided to launch a company, the promoters have to select a name for it and submit an application to the Registrar of Companies, ROC, of the state for its approval. The proposed name must not be same or similar to that of another existing company. Four. Fixing up signatures to the Memorandum of Association, MOA. The promoters have to decide about the members who will be signing the Memorandum of Association, MOA. Regarding the signatories to the MOA, usually the people signing the MOA are also the first directors of the company. Their written consent to act as directors and to take up the qualification shares in the company is necessary. Five. Appointment of professionals. Promoters appoint merchant banker, auditors etc. are appointed by the promoters to assist them in the preparation of necessary documents which are required to be with Registrar of Companies. Six. Preparation of necessary legal documents. The promoter takes up steps to prepare certain legal document which have to be submitted under the law to the Registrar of Companies for getting the company registered. 1. Memorandum of Association. 2. Articles of Association. 3. Consent of proposed directors. 4. Agreement. 5. Statutory declaration. 6. Receipts of payments of fee. Necessary legal documents. 1. Memorandum of Association, MOA. It refers to that basic documents of the company in which those conditions are stated on the basis of which a company is incorporated. Contents clauses, MOA. Name clause, name of the company. Registered office clause. Object clause, purpose for company formed. Liability clause, liability of the members. Capital clause, authorized capital and soon. 2. Articles of Association, AOA. It refers to that document of the company in which rules of internal management to achieve the objectives laid down in the MOA are stated. The Articles of Association must be printed, divided into paragraphs and serially numbered. The signatories to the Memorandum of Association must sign it and it must be duly attested. Content clauses. The amount of share capital and different classes of shares. Procedures for making allotment of shares. Procedure for issuing shares certificate. Procedures for forfeiture and reissue of forfeited shares. Rights of each class of shareholders. Procedure for conducting meetings, voting quorum and proxy. Procedure for appointment, removal and remuneration of directors. Procedure for declaration and payment of dividend. Procedure regarding alteration of share capital. Procedure regarding winding up to the company. 3. Consent of proposed directors. Apart from MOA and AOA, a written consent of each person named as a director is required confirming that they agree to act in that capacity and undertake to buy and pay for qualification shares as mentioned in the AOA. 4. Agreement. The agreement, if any, which the company proposes to enter with any individual for appointment as its managing director or a whole-time director or manager. 5. Statutory declaration. A declaration stating that the legal requirement pertaining to registration have been completed. 6. Receipt or payment fee. Along with the above-mentioned documents, necessary fees has to be paid. The amount of such fees shall depend on the authorized capital of the company. Incorporation registration. It means registration of company as a body corporate under the Indian Companies Act, 2013. Application for incorporation. Promoters make an application for the incorporation of the company to the Registrar of Companies along with necessary documents. 1. Memorandum of Association. 2. Articles of Association. 3. Statement of authorized capital. 4. Written consent of proposed directors to act as directors and undertaking to purchase and pay for qualification shares. 5. Agreement with proposed managing director or whole-time director or manager. 6. Copy of registrar's letter approving the name of the company. 7. Notice of the address of the registered office. If the notice is not submitted at the time of registration, it can be submitted within 30 days of the receipt of the certificate of incorporation. 8. Statutory declaration affirming that all the legal requirements for registration have been complied with. This must be signed by an advocate of a High Court or Supreme Court or a signatory to the MOA or a chartered accountant or company secretary in whole-time practice. Certificate of Incorporation. Birth certificate and its effect of the company. When the registrar is satisfied about the completion of the formalities for registration, a certificate of incorporation is issued to the company. With effect from November 1, 2000, the Registrar of Companies allots a CIN, corporate identity number, to the company. A private company can immediately commence its business. It can raise necessary funds from friends, relatives, or through private arrangement and processed to start business. Effects of incorporation. Effects of incorporation are as follows. 1. Company becomes an incorporated entity. 2. Certificate of incorporation can be presented in court as a proof of the existence of company. 3. Company becomes an artificial person created by law and its identity is considered separate from its members. 4. Identity of company becomes permanent. 5. A private company can start its business just after receiving the certificate of incorporation. Capital subscription commencement of business stage. A private company or a public company which does not have share capital can commence its business just after getting incorporated. Hence, capital subscription stage or commencement of business stage apply only to public company with share capital. 1. SEBI approval. SEBI, Securities and Exchange Board of India. SEBI has issued guideline for the disclosure of information and investor protection. A public company inviting funds from the general public must not conceal, hide, any material information from the potential investor. A public company is required to take prior approval from SEBI to raise funds from public. 2. Filing of prospectus. A prospectus is to be filed with the Registrar of Companies. Prospectus means any document which invites deposits from the public or invites offers from the public to purchase shares or debentures of the company. Prospectus. It refers to that document which contains the all relevant information to the issue and through which the company invites the public to apply for shares, debentures. Statement in lieu of prospectus. It refers to that statement which is filed with the Registrar of Companies in case a company not issuing the prospectus. 3. Appointment of bankers, brokers and underwriters. Raising funds from the public is a stupendous, impressive work. It involves mainly 3 parties. Banker application money is to be received by the bankers of the company. Broker, the brokers try to sell the securities by distributing the forms and motivating the public to apply for the securities. Underwriters, they undertake to buy the shares if these are not subscribed by the public. They receive commission for their services. Appointment of underwriter is not mandatory for the company. 4. Minimum subscription. In order to prevent companies from commencing business with inadequate resources, it is provided that a company must receive the amount of minimum subscription in cash within 120 days from the date of issue. Minimum subscription is 90% of the issued amount, size of issue. Otherwise, the allotment cannot be made and the application money received must be returned to the applicants within the next 10 days, i.e. 130 days from the date of issue. 5. Application to stock exchange. As per this step, It is mandatory to apply to at least one stock exchange for permission to deal in its shares or debentures. In case this permission is not granted before the expiry of 10 weeks from the date of closure of subscription list, the allotment shall become void. As a result of this, all money received from the applicants will have to be returned to them within 8 days. Six. Allotment of shares. Till the time shares are allotted, application money received should remain in a separate bank account. Refund or adjustment of excess money received. In case the number of shares allotted is less than the numbers applied for, the excess money is to be refunded to the applicants or adjusted towards allotment money due from them. In case where no shares are allotted to the applicant, the whole money is to be returned to the applicants. Allotment letter are issued to the successful allottees. Finally, a return of allotment, duly signed by a director or secretary, is filed with the registrar of companies within 30 days of allotment. After fulfilling all the formalities, the registrar will issue a certificate of commencement of business. Such a certificate is a conclusive evidence that the company is entitled to commence its business. Main documents used in company formation. I. Memorandum of Association, MOA. 2. Articles of Association, AOA. 3. Prospectus. I. Memorandum of Association. The Memorandum of Association is an important document of the company. Memorandum of Association contains those conditions on the basis of which a company is incorporated. A company cannot be incorporated without. In this document, the rights and objectives of the company are defined. Memorandum of Association defines the power and objects of the company as well as the scope of operations of the company beyond which it cannot operate. Content clauses of Memorandum of Association. The Memorandum of Association contains the following 6 clauses. 1. Name clause. 2. Registered office clause, situation clause. 3. Objects clause. 4. Liability clause. 5. Capital clause. 6. Association clause. Articles of Association, AOA. The Articles of Association is the second important document which is prepared by the promoters. For the purpose of incorporation, it is presented before the registrar along with other documents. The Articles of Association of the company is prepared in accordance with the Companies Act, 2013 and the Memorandum of Association of the company. It is an assisting document to the Memorandum of Association. The Articles of Association contain internal rules of the company which can be said as the assisting rules to the Memorandum of Association of the company. In this document, rules and regulations for attaining the objects stated in the Memorandum of Association fixes the objects of the company and the articles tell the ways and modes of attaining the objects of the company. Content of the Articles of Association. The following points are mentioned generally in a company's Articles of Association. 1. The amount of shares capital and different classes of shares. 2. Procedure for making allotment of shares. 3. Procedure for forfeiture and reissue of forfeited shares. 4. Procedure for issuing share certificate. 5. Rights of each class of shareholders. 6. Procedure for conducting meetings, voting, quorum and proxy. 7. Procedure for appointment, removal and remuneration of directors. 8. Procedure for declaration and payment of dividend. 9. Procedure regarding alteration of share capital. 10. Procedure regarding winding up of the company. Contents of Articles of Association. 1. Mode of ratification of preliminary contracts. 2. Division of various types of shares and rights of shareholders. 3. Mode of issue of shares and allotment of shares. 4. Fixation of minimum subscription. 5. Method of issuing share certificates. 6. Rules regarding calls on shares. 7. Mode of increase, decrease or restructuring of share capital. 8. Payment of commission and brokerage on shares and debentures. 9. Consolidation and division of shares. Prospectus. The prospectus is the third important document in relation to the formation of a company. Generally, the prospectus is issued by a public company to obtain money from the public. The promoters of company generally issue prospectus after obtaining the certificate of incorporation. It is the chief source of attracting the attention of the public regarding the birth of a company. In this way, the prospectus is an advertisement of a company. According to the Companies Act, power to issue a prospectus is only a company having share capital. A private company can commence its business immediately after incorporation. Objects of prospectus. Following are the objectives of issue of the prospectus. 1. To invite the public to purchase shares and debentures. 2. To give details of those conditions on which invitation of purchase shares and debentures is given to the public. 3. To declare that the promoters will be liable for the information contained in the prospectus. Contents of the prospectus. The prospectus is such a basic document of a company which attracts the public to invest their money by making them aware of the company's commercial planning and its profit-earning capacity. So, it is necessary that prospectus should indicate the real picture of the company's position. The following details are given in the prospectus. 1. Main objects of the company and signatories of the Memorandum of Association. 2. Share capital. 3. Managerial personnel. 4. Minimum subscription. 5. Opening of subscription list. 6. Application and allotment money. 7. Shares or debentures issued for consideration other than cash. 8. Share premium. 9. Underwriters. 10. Preliminary expense. 11. Promoters. 12. Auditor. 13. Details of business. 14. Property acquired. 15. Restriction in articles. 16. Capitalization of profit reserves. 17. Time and place of inspection. Different form of business organization. 1. Sole proprietorship. 2. Partnership. 3. Joint Hindu family business. 4. Cooperative society. 5. Joint stock company. Factors influencing the choice of a suitable form of business organization. 1. Nature of business. 2. Cost and ease in setting up the organization. 3. Degree of risk involved and liability. 4. Continuity. 5. Freedom from government regulations. 6. Degree of control. 7. Management ability. 8. Capital considerations.